All right. Good evening, ladies and gentlemen. I was just talking a little bit about this photo that I took today of these toucans that were sitting out on this perch. I have a direct view of this from my office. You know, we're all here, I think, to perhaps advance a little bit, at least, towards achieving freedom. And I've got these toucans that fly around my house occasionally. You know, they're kind of fleeting. They come and go. I don't see them very much. Occasionally I'll see them both. And they're a pair, by the way. They're always together. Occasionally I'll see them fly by from, I've got forest on both sides of my lot. So there's kind of an open space in between. And so they'll fly from one side to get to the other side. And I'll see them occasionally there. But, you know, you look at these guys sitting here. And it just seems so perfect. You know, here they are, beautiful creatures, look to be in great shape, good health, just sitting on this perch high up above the trees. I'm up on a mountaintop, and so the trees themselves are looking down on the valley below. And just, as the saying goes, free as a bird, enjoying the view, enjoying the fresh air, enjoying the freedom. No one is there to bother them or to molest them or to get in their way with any demands of any kind. They can be their own person, do their own thing, come and go as they please, with no one to really get in their way. And isn't that what we're trying to accomplish? Lord, oh Lord. If only, huh? So that's this kind of epitomized to me what we're trying to do here. You know, a lot of us get involved in these legal issues and trying to study these procedures and documents and research and history and updates and this process versus another process. And you know, it's just really a psychological and emotional burden that we shouldn't have to be dealing with. We simply shouldn't have to be dealing with that. That's not the design. That's not the plan. That's not why we are here. But, you know, I just know from my own experience and also from watching other people, you know, we commit the majority of our day towards just survival. And then on top of that, we try to do some things to get out of the clutches of the evil ones. And, you know, where's the time for personal development, self-improvement, family, recreation, exercise, health, study, music? I mean, so many things we should be doing that obviously we're not. You know, I'm an old guitar player. I love to play guitar. And I don't have the time to play. I mean, I'm freer than most, and you know, judging by this view from my office, I know I've got it good. But you know, I'm committed to what I do, and I'm like you probably. I'm, you know, just overloaded with activities, and so where's the time to really become ourselves? So I just wanted to revisit that a little bit and share that with you. And maybe help us all realize that this is really the end objective. This is the goal, I think, for most of us, you know, is to get out of some of the ruts that we might be in and generate a little bit of liberty and freedom, kind of like these toucans. So with that, let's go ahead and get started. All right, so what we're going to do today, speaking of freedom, one of the most oppressive control and domination systems using fear and intimidation that exists, of course, is the IRS. And I don't need to tell you much about that, but That's an issue that affects us all. It's an organization that affects us all. I'm currently producing a video about the Montana Freemen. I'm in contact with Dan Peterson and doing some interviews and putting some things together. In the process of doing that, I was revisiting the story of Gordon Kahl. Some of you have probably heard that name before. Back in the 80s, he was just a dirt poor farmer. Didn't have any money. Didn't make enough money to even meet the threshold of being required to file anything to the IRS. Okay, he didn't make enough money. He was a poor guy, a poor farmer out in the country. Anyway, long story short is he got on the radio one time, started talking about the IRS and what a bunch of scum they are, how illegal it is, and the fraud that they represent. And this radio station started getting all kinds of calls, people calling in, hey, he's right, I'm not going to file either. Yeah, I'm with him, and all this kind of corroboration. And from all the fuss that he created with this radio show, he quickly became a target. Well, a very long and very horrific story short, he ended up going into prison. He got out, and the feds wouldn't leave him alone. They wanted to bring him back into court, harass him some more, and he said, screw you, I'm not coming. And by the time it was all said and done, they sent a Delta Force team out by private jet from Washington, D.C. to kill him. And he escaped their surveillance for quite some time. And finally, they caught up with him, found out the house that he was in. They laid down a barrage of fire, all kinds of guns and rifles. And he survived that. They came in the house, they found him alive. They took an axe, they chopped off after beating his face in and smashing his teeth in with the butts of their rifles and breaking bones and ribs and bruises all over his body. They took an axe and they chopped off his left hand. He was screaming in pain and bleeding profusely. And that wasn't enough, so they chopped off his right hand. And they went and proceeded to chop off both of his feet while he was alive, of course. And of course, he's screaming in terror, bleeding profusely. And they finally pulled a gun up at close range and put a bullet in his head. This was a poor farmer who wasn't required to file, talking about not filing. And he wasn't required to file to begin with. He didn't make enough money. And this is the thanks we get from some of the people that feel that they need to dominate us. All right. So naturally, we're dealing, I say it all the time, if this is perhaps one of your first few visits with me, but we are dealing in a spiritual battle here. People like that are certainly possessed by demons. They aren't human. They have no compassion. And it's a different animal altogether. So we have to recognize that. And I think develop our spiritual walk with God importantly, and then fortify ourselves with knowledge. And that's what we do here in the Law Club, is try to fortify you with that kind of knowledge that will help you. All right. So what I'm going to talk about a little bit today is the IRS. And we'll get started on that. I've got David Merlin is going to be joining us a little bit later, talking about the issue of mens rea, willful intent. There have been some Supreme Court cases that have come out here not too long ago that have kind of turned the whole world of prosecution on its ear, because they usually bungle that as an element of the crime and they don't prove it sufficiently. And so people are going back and getting criminal convictions overturned. And David will talk about that. He'll be coming up maybe in 15, 20, 30 minutes, something like that. But in the meantime, let's talk about the IRS. And, you know, beating the IRS, it's so easy. It's just, let me put it this way, it's simple. The concept is simple. Doing it perhaps is not as easy as it is simple, but you get the idea. All right. All right. On the onefreemanswar.com webpage, I've got a page here under Advanced Solutions, the IRS Freedom Package. Okay. And that kind of explains a little bit about what's in this package, and there's a number of people that come and take this separately. This package is included in the mastermind, in the Constitutional Commandos Mastermind Group membership. Okay, so there's no extra cost for this if you're a Constitutional Commando, or some people just go and they get the course separately. But it's amazing how simple it is to be able to beat the IRS. And I talk a little bit about that in the on-demand video workshop that I have on Vimeo, vimeo.com/Mark Emery. In this on-demand seminar, it's the previous taxpayer, and it boils down to this. I'll give you the bottom line right up front, that there are two roads that the IRS travels on, and there's only two ways they can get you. Civilly, they can get you with a civil action, get a judgment, place liens. Of course, they don't need a judgment to do that anymore since they've dispensed with legal and lawful processes. But civil actions, they can try to steal your stuff, right? That's the bottom line. They'll take whatever they can get. And that being the case, you know, a lot of folks, they get the IRS Freedom Course thinking that that's some kind of a magic wand that's just going to be like a silver cross to a vampire and they just go running away. No, that's not the case. I want to make a very strong point here that when you're dealing with the IRS, you have to understand that you are dealing with lawless criminals. They don't care about the law. They don't care what kind of paperwork you have or what you send them, notices, whatever. They don't care. They will steal from you if they can. All right, so don't think you can file something and they're just going to go, oh, okay, you win, and we'll go away, leave you alone. It doesn't work that way, okay? We have to be practical here and deal with reality. So the solution to that is really simple. And the solution is don't have anything in your name that they can get a hold of. Take away all the low-hanging fruit so they cannot steal from you, all right? So that includes bank accounts in your name. You have to learn how to conduct your life without a bank account in your name, perhaps, all right? Get property out of your name, vehicles, and most importantly, your cash flow and revenue. That's the biggest tie down that most people have. And I see that as being the issue where people give the most resistance. You know, the only way to be free and independent is to have your own independent cash flow. And if you've been around, you hear me talk about that just about every time I open my mouth. I'm sorry if you're tired of hearing it, but I will keep saying this for the benefit of those who perhaps haven't heard it before. You've got to get rid of that corporate job and you've got to develop your own independent sources of cash flow. And these days, it's not that difficult. With the internet and computers and the free training that we give in the Digital Nomad course to get you started in building an internet marketing machine, funnel system, landing pages, all those kind of things, it's not that difficult. All you have to do is apply yourself. So, take away the low-hanging fruit. Don't let them hurt you civilly. So don't think that by filing any kind of paperwork, no matter how good it is, no matter how strong it is, they're not just going to go away. If they can steal from you, they will. If they can go into your bank account and clean it out, they'll do it. If they can file a lien, force you to pay them if you ever end up selling your house, which is in your name, they'll do it. Okay? So one book I highly recommend, you probably heard of it, is the Japanese warrior Sun Tzu. Sun Tzu, The Art of War is the title of the book. And one of the key elements to victory, teaching his book, is that never underestimate the enemy. Never think, oh, they're just going to go away. Oh, they'll leave me alone. Oh, they're not going to do this. They will. Look what they did to Gordon Kahl. Remember what they did to Gordon Kahl. Never underestimate the enemy. So you've got to learn to take these things away from them so you can't be hurt, so things cannot be stolen from you. Okay? So I get into that here a little bit on this particular workshop online, and that's important. The other road that they travel on is the criminal road. All right, so the two roads they travel on are civil, they'll steal from you if they can, or criminal, they'll throw you in jail if they can, because they make money that way. I think you understand that. With the bonds that are created and immediately go off into market and feeding the private prison systems and all the things that are supported there. It's big business, all right? So they can make money off of you and get their money by sending you to jail. How do you avoid that? Well, that's really simple. Let me show you what we do in the IRS Freedom Course. You take away willful intent, okay? You don't say, like Gordon Call did, screw you guys, I'm not playing your game. No, that's not the way to do it. You say, yeah, okay, you want me to pay $100,000 on this $500 5-year-old tax bill that I had. Okay, well, I'll pay it. I'm here, I'm willing and able and happy to pay it. Just show me a few things that you've got, sound legal ground to stand on to ask that from me. All right, so in our IRS Freedom Course, this is what's involved. We've got a folder on education and training. What I'm talking about now is we send in a notice of offer of performance. It's like, okay, I'm going to offer to perform for you. I'm going to do what you want, all right? But my offer is conditional. And it's conditional upon these 5 or 6 things that you need to provide for me to show that you have a bona fide, verified claim, you have proper legal standing to request that claim from me, you meet all the legal and lawful requirements of being a creditor to demand payment, okay? And let's see if I can get it opened up here. All right, so we're going to go here, notice of offer of performance. Now, in the Uniform Commercial Code, there is a section in the UCC which states very clearly that an offer to pay in full, which is refused, is a debt paid at law. So if you make this offer to pay in full and they refuse your offer, then by operation of law, that debt, so-called debt, is paid, okay? So in this particular document, we start off by establishing a few foundational points in an affidavit, and then we make an offer to extinguish the alleged tax liability. Notice we call it the alleged liability because we haven't necessarily agreed to it yet. They're asking for it, and we're agreeing conditionally, okay? And so this gets into some legal precedents. And so here's what we're going to ask of them. All right, starting up at the top, this offer is to pay a certain sum to the agency, which is asserted as a tax liability, and we're going to pay it in full or in agreed installments, whatever you agreed to, including interest and penalties. So I'm going to pay everything. This offer is made dependent upon performance of conditions precedent to which I am entitled by the fundamental principles of American jurisprudence and law. Namely, I need you to present documentary evidence showing the factual grounds of the alleged tax liability. And then I break it down. 1, documentary evidence of the legislative act creating the Office of the Department of Treasury Internal Revenue Service. Doesn't exist, right? Documentation or documentary evidence of the codification of the legislative act, okay? In the Code of Federal Regulations, which are the implementing regulations. Quite often in the Internal Revenue Code, they might have a statute, but they don't have any implementing regulations behind it. All right, and I get into that in my book, which I'll show you how to get for free, How I Beat Satan and the IRS. Then also provide me, number 3, documentation or documentary evidence of the publishing of such act in the Federal Register, which is required by law. Since you, the proponent, has the burden of proof, all pursuant to Title 44 of the U.S. Code. Okay, so that's number 1. B, number 2, show me documents or documentary evidence showing the facts necessary to establish that I, the undersigned, am specifically and unequivocally made liable by the law for the payment of a particular kind of tax alleged by the IRS. And again, we know there is no such law, okay? But they're trying to intimidate you with the law. So you say, okay, show me the law that this is required and I'll pay it. All right, show me the clearly identifying the particular statutes, code, and regulations that allegedly create that liability. All right, C, show me facts necessary to establish that I, the undersigned, am subject to the legislative jurisdiction, regulation, and control of the legislative entity. Now, of course, that was the purpose of our affidavit, to establish you're a living, breathing man, not a dead corporation as a U.S. citizen, okay? So they've got to rebut that affidavit and bring evidence to show that you are a corporation. All right, D, show me the facts necessary to identify the specific property upon which the tax has been imposed by legislative enactment, okay? Taxes have to be imposed on, specific transactions or property. E, show me facts necessary to establish that such property upon which an assessment has been made actually came into my possession, ownership, and control. And then last, documentation of facts necessary to determine how Title 26 of the U.S. Code, Section 83, factored into the calculation of the alleged amount due and owing. The courts have well established that compensation for services rendered is not subject to Subtitle A, income taxes. That's what Section 83 is all about. And our guest coming up, David Merlin, has done extensive research on this for you. He's written a book on this Section 83. And just that alone is enough to give him enough blowback to at least take the high road morally and legally. Okay, so if your alleged taxes were based on so-called income from wages earned in a payroll check, then Section 83 basically states that that's not subject to Subtitle A, income taxes. Okay, so hey, you guys, I'll pay whatever you want. All right, just show me that I owe it. Show me you're legitimate. Show me the law. Show me how you factored that alleged tax versus Section 83, and we'll start negotiating, the arrangements for payment. All right, and then of course we go. We use the doctrine of estoppel, that if they don't respond in a certain period of time, we can only presume that they don't have answers for this, therefore they don't have a legitimate claim. Goodbye, see ya. All right, and so this document is couched in such a way that, hey, I want to pay this, I'm making an offer to pay, I'm acting in good faith and fair dealing, and I'll presume you are too. So let's just deal with this and get this taken care of. All right, so this shows you're trying to settle the matter in a good faith manner. Okay, so this eliminates intent, willful intent to avoid your legal obligations. Okay, so for criminal charges to stick, you've got to have, first of all, there has to be a clearly defined legal duty. All right, we've asked them to show you the legal duty. They won't because they can't. All right, once there is a legal duty, you have to know about the legal duty, and you're asking them in this document, hey, if I'm wrong, please tell me, show me, help me out here. I want to comply with the law. I want to be in good shape with the IRS. Show me where I went wrong. Okay, help me out. Let's work together on this. You're acting in good faith. All right, so you have to know about the duty, the lawful duty to do that, and then to have criminal charges stick with you, they have to show that you willfully avoided or evaded that known duty willfully, intentionally, and voluntarily. Okay, so with this document, it just completely knocks willful intent right out of the box. All right, so if you don't have anything they can steal with a civil matter, all right, that road is closed. With a document like this, you've just closed the criminal road that they travel on. And there are no other roads for them to travel on. If they can't throw you in jail and they can't steal anything from you, guess what? Here you are. You're one of these toucans sitting up on the perch, free as a bird. Go where you want, when you want, do what you want. Don't worry about anything. All right, so it's that simple. It's not difficult. It's a simple thing. Now, to position yourself, that's part of the process, to start doing, I don't want to say doing business, but to start managing your life in such a way that you can be protected. So that's that. All right, I'm going to shut this down. So being the IRS is not that difficult. You just need to position yourself properly, learn how to manage your life in a way that you don't set yourself up to be plundered. Watch out for the highway robbers, take the safe route, and be done with it once and for all. Okay, so if you just want to find out more about it, you got the, go to Vimeo, vimeo.com/Mark Emery. You'll find a couple of workshops along those lines. If you just want to stick your toe in the water, if you're not ready to become a full member yet, you got the course that's available, IRS Freedom course. You can get that separately on onefreemanswar.com. And really the best thing to do is just become a member as a constitutional commando. And all those things will be included and a whole lot more. Okay, so just to give you an idea, kind of grease the wheels a little bit so that they start turning in your head. David and I have known each other for some time now, are equally committed to the battle for truth. We both kind of have our different avenues for doing that, and just like all of us do, really. I mean, we've all got different skills, talents, and experiences, and we kind of shape our lives around that. David is an impeccable researcher, writer, and legal mind, having written just really innumerous documents, books, research papers on a variety of subjects on law and the labyrinth of law that exists out there. And he's an excellent source for helping us all to try and make some kind of sense out of it. Really, David, without your work, I'm sure so many of us would still be lost in so many different areas. So I really applaud you on what you've done. I only hope and pray that that people can use it for their benefit as much as possible. So with that, we'd like to hear from you and no more from me, I think. Tell us about your training program with Mens Rea, what that's all about, and you probably have your own agenda, but I'd like to maybe hear a little bit about the Supreme Court cases that have come up in the past that kind of support all this, and what that's doing to help people who have been charged with criminal charges. So go ahead.
Okay, welcome to Mark's Lighthouse Law Club forum. My name is David Merland. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. Believe it. It's June 21st, 2017. So much of what I do is, I should rephrase that. What I do is so very closely related to a lot of things Mark said leading up to my turn at the call here. You'll never get a thief to admit that they're a thief. But what I bring to the party is unique in as much as I know exactly which tax code statutes that the IRS is violating in its standard operating procedure. In 1988, the IRS made me angry, and I was like the world's fastest bartender. 6'3", 178 pounds. I could slam dunk basketballs, long arms, big hands, photographic memory, and a bartender's attitude. And I didn't like the way I was treated when the IRS confronted me over having not claimed any tips in 1984. My tips would have claimed out at $7,200. You do the math. That means I had over almost $100,000 in personal sales that year in cocktails. So I was an extremely gifted, high volume bartender, and just a fantastic mechanic. And the IRS made me angry, and I looked around at my life. I said, I got a 2-car garage wood shop at my house, and I make an oak school chair. I've got it in 5 furniture stores. You undo a hook on it and folds over into a 4-step step stool. And I said, I can, look at what I can do bartending. I do long division in my head. And I think I could do tax law. And so I started studying tax law in June of '88. And by October of '98, 10 years later, I had written everything it took for 5 people to go all the way to the Supreme Court on my 1994 treatise about the difference between the tax code and the IRS. The differences between the tax code and the IRS. That means violations of the law. That's what that means. I studied enough of the tax code to where my findings and research led me into places in the tax code you don't hear other people arguing at all. And I made a list of these arguments, and then you put each one of them on the scale to weigh how much damage they would actually do to the IRS if proven valid. And I played it straight. Beginning in January of '94, I had already forced them to rewrite an IRS publication and a Treasury regulation. And a year later, they rewrote the U.S. passport application because of me. And it wasn't because I was out there putting bombs in mailboxes like Pete Hendrickson. It was because I was challenging regulations and language of their publications and forms. In brief, first briefs I wrote in my life, late '93, early '94. I made a list of these arguments and put the biggest ones at the top and the smallest ones at the bottom. And when you look at the way I'm arguing the tax code, you compare it to everyone else out there. No one is making these specific challenges, and yet, if true, they do the number on the IRS for everybody in the 50 states. Period. You've got, and I'll outline my 2 primary arguments, but just so you don't bag the call, if you find this topic not interesting, the litigation that's going on right now is profoundly revealing. I don't tell the government, show me the law. I show them the law and say, you're breaking these laws by taxing the value of my labor. You're breaking these laws by applying the tax code to Americans. You call us citizens of the United States? Well, if that's what I am, let's look at the tax code and see if it applies to citizens of the United States. So all you hear from me at first is, okay, I'm a citizen of the United States. Arguendo. That means for the purposes of argument, sure. Let's argue a little bit. I'm not going to waive any rights. I'm not going to concede to anything. It's about whether or not they have the authority to talk to me. And I'll tell you what, they're after my money. Did you know that? Government, you, me, we all want the same thing. Our property. And the government is the only one that doesn't have its own property. It has to go out and get it. and it's after me. It's after you. And so the first thing I want to know is, do you have the authority under the law to demand money from me? You call them taxes. You say it's the Internal Revenue Code. Okay. But first, let's look at a couple of points. Title 18, Section 241. It's our criminal code. There are some drug charges that are in other titles. But 18 U.S.C. 241, if two or more persons conspire to threaten, injure, or oppress any other individual in their exercise or enjoyment of a right secured by the Constitution or under laws of the United States, 10 years in prison, maximum. That's a felony. And if I don't owe the money, if the law doesn't reach me, and yet they're trying to get my money, how is it not a conspiracy against my rights? How is it not? They're conspiring to steal my money. That's 10 years in prison. You know what comes along with reasonable suspicion a felony has been committed? The common law right to make a citizen's arrest of the felon that's been codified into state code in nearly all the 50 states. So if I come across a felony, I now understand I have every right to physically apprehend that person and take them to authorities competent to take them into custody. That's the way a citizen's arrest goes. I went through the entire LexisNexis case law database for federal cases, U.S. District Court, U.S. Appellate Court, and Supreme Court cases that say citizen's arrest of a felon is just fine. In fact, there's one particular case, the name escapes me, the name of the case. The person says, hey, this postal inspector, they don't have the authority to make an arrest, and he busted me for like possession of stolen mail or possession. I can't remember how the case was, but they said, the government said, you're right. As a postal inspector, or it was a postal employee of some sort, he doesn't have the authority to arrest you. However, or it was over jurisdiction. He was outside of his state or outside of his county, whatever. There are some cases like this where the officer was outside of his jurisdiction or the postal inspector had no authority. But the court decided, well, you know, he kind of suspected that a felony had been committed. And so even though along with his job, he gets no authority to arrest you outside of his jurisdiction or because he's just postal or whatever, he does have the authority as a private citizen to arrest you. And so it was not a false arrest. And so they traversed to the right of a private citizen to make an arrest when the officer was outside of his jurisdiction, but had reasonable suspicion that a felony had been committed. Why on earth would anyone not want to familiarize yourself with that parameter of your rights before speaking to a public servant about your rights? If they're engaged with their boss, whether it's the IRS commissioner, the county sheriff, the police chief, if they're engaged with their boss in a conspiracy to misapply the law, to steal my money, to coerce me into a payment of what I don't owe, that's called extortion, and do it in a pattern against me and others, that's racketeering. These are federal felonies. And so I want to know all of my rights first. Then I speak to a public servant. And when they say, you're subject to the tax code. Well, why is that, servant breath? It's because you're a citizen of the United States. Is that right? Okay, begin. I have two primary arguments. And Mark will tell you how to get a hold of my materials. And again, this is a 1994 treatise. Since 2006, my office has prevented more than a dozen indictments. We've closed down IRS criminal investigations, a couple of grand jury investigations, and it turns them off in advance by proving that, excuse me, the law is perfect. You're stealing. I know you're stealing. You can't even deny it because I got all the docket numbers to prove it. I filed a 180-page package, which was a criminal complaint with 80 members of Congress, New Year's of '06. Had a complete briefing of my heaviest hitting arguments from my treatise of '94. And that's what people wield in their defense to say the law is perfect. You're stealing from me. You're felons, aren't you? Here's a racketeering complaint filed with Congress, and I've joined it. I'm a similarly situated witness to crime. I saw you coming, so I joined it, reported you to Congress. So I got a question here. You say I'm a citizen of the United States, that's fine. We know then, and therefore, I'm not the citizen in chapters 2, 21, and 23. Those are respectively Chapter 2, Social Security Self-Employed. Chapter 21, FICA. Chapter 23, matching FICA excise tax on employers that they usually just pass off on the employee. And so that leaves just Chapter 1 of the tax code. And I say this because the statutory definition of citizen in those three chapters obviously exclude citizens of the United States. It says so right in the definition. Okay? So that leaves just Chapter 1 of the tax code. And what you're hearing for the first time is an explanation of how taxes are actually imposed by the tax code. So now I'm left with just Chapter 1 after having proven that Social Security has, since 1935 when it was first enacted, it's always been theft, racketeering, extortion. Just Chapter 1, and there is no definition of citizen in statute. There's no statute where Congress, under their 16th Amendment authority, laid and collected an income tax on a citizen of the United States. And so the Treasury wrote Regulation 26 CFR 1.1-1, saying, who owes this tax? Citizens of the United States. Wherever they live? Yep, wherever they live. Well, the statute doesn't mention citizenship. Section 1 of the code, the graduated income tax, it doesn't mention anybody's citizenship. You can't write a regulation that does. And I've been challenging that regulation as invalid and telling the courts this is a violation of the 16th Amendment because the regulation identifies the subject of the tax instead of Congress. That kills the whole tax code, if correct. But it also demands of a thief that the thief admit they're a thief. I'm not a dreamer. And so I've limited my attempts to criminal cases. I try to keep people out of prison. I've been real good at it. I've gotten real good at it, excuse me. Second argument, even if I were, because now I've lost my first argument, they're going to steamroll me now that I'm inside the tax code. How did you calculate my cost when you say I owe a tax on the value of my labor? And they say, we don't calculate a cost. We include it all in gross income. Well, you have to calculate cost first. And you do that with tax code section 83. I'm the only one in the known universes teaching tax code section 83. And yet, circuit courts, tax court, Chief Counsel of the IRS in Revenue Ruling 2007-19. These are some of the quotes from these cases. Section 83 applies to any and all compensation paid for services performed by an employee or an independent contractor. Goodmanson versus U.S., Second Circuit, 2011. At the heart of this case is Internal Revenue Code Section 83A, which explains which governs the taxation of property transferred in connection with the performance of services. Revenue Ruling 2007-19. Tax Code Section 83 provides for the determination of what is to be included in gross income when property is transferred for services performed by an independent contractor or employee. So we don't have a choice. You have to comply with it. You have to comply with it. Period. So you have Pete Hendrickson saying it's gibberish. Well, you don't have that luxury because they'll kick your butt with the law. It's never gibberish. You can't win that argument. You have to get into it. You're an American. You're an adult. It's one paragraph, 83A. Apply it to your labor. And what was your conclusion? If I'm frivolous, if I'm wrong, what was your conclusion? There is a guy that went to an administrative hearing on a summons less than 2 weeks ago, and he hit him point blank. Is the IRS in violation of or in compliance with Tax Code Section 83 when you say I owe a tax on my compensation? And he's talking to two IRS officers. Agents cannot recommend prosecutions. Officers can. And they're there to enforce a summons. Do we have to sue you to get your books and records? And he says, well, first, if you can't even tell me that you've considered the law, Section 83. And one of them she says, well, are you telling me you'd like me to research Section 83? Back up. Hold it right. Excuse me. You can recommend prosecutions? And you're asking me if I would like you to know something about the law that explains whether or not I owe a penny? Really? And they can destroy your lives. And they had never heard of Section 83. I've been clubbing them like a baby seal and calling animal control to scrape up their flaming carcasses with snow shovels since 1993. In 1994, I wrote my manual called Codebreaker, the Section 83 equation. In 2014, I added 30 pages to it and published it. Talk to Mark. I'm the only one in the known universes that even teaches the statute. And here they are on tape. He told them, I'm taping this. And they're both talking about, okay, when are you going to give us your records? And he goes, well, Section 83, have you considered that? And they go, what does this say? What is this Section 83? On tape. It's amazing. It explains how to tax your paycheck. And I can't describe to you what the only thing I can picture them doing to themselves while they're saying these things. It's obscene. And the reason Section 83 is such a stickler, get the manual. There's also, and I'll tell you here in just a second, this is part of my fingerprint, okay? I've been doing this backwards and forwards, upside down, in essays, in statute, and every other way I can express it, this Section 83 argument. There's a flash drive you can get from Mark. It has 7 video segments on it, 3 hours, 45 minutes of instruction total, where I explain different arguments. And at the end, there's a segment called Tax Code from the Ground Up, where I line all the statutes up to protect you, and then I show you all the regulations they wrote to change a perfect tax code into the IRS. And these are the 2 biggest arguments. The first one, how did you apply the tax code to citizens of the United States? Just a regulation? You can't do that. Secondly, if I'm inside the tax code and only sold my labor, how did Section 83 operate in your conclusion? I owe a tax on my paycheck. They can't talk to you. If in connection, first off, the statute's called property transferred in connection with the performance of services. Sounds like a paycheck to me. I'm the only one on the planet teaching it. That includes accountants and attorneys. Lowell B. Craft debunks everybody he can debunk. He won't touch this, and he has all of my work. I sent him an email the other day about all the litigation I'm in right now from coast to coast, different circuits. So Section 83 is called property transferred in connection with the performance of services, and everybody missed it. And when I found it, I immediately went to the law library because I said, if this applies to me, it's not being enforced, because it doesn't say the whole paycheck's gross income. It says, if in connection with the performance of services property is transferred, the excess of the value of that property over the amount paid is gross income. Not the whole thing. The excess over the amount paid. And the amount paid is defined in regulation. Hang on, I'm typing here. Regulation 1.83-3G as the value of any money or property paid. There's approximately 10 trillion cases that say the term any is all inclusive. When you come to the term any, it means everything, unless the law thereafter says there are exceptions. And so they look at the term any money or property in this regulation that says that's what cost is, and they say, except labor. And the challenge is, where's your authority to exclude labor? The law says any money or property, and they can't talk. I've got the labor argument all the way down to that. The second biggest argument, the first one is, how does the tax code apply to Americans? Regulation only. The second one, is there an income tax imposed on the value of my labor? No, only on the excess over the value of your labor. Section 83 says so. They can't get out of the argument. And so it's up to the judges to save them. Here's the punchline. South Carolina, a lawsuit was just dismissed. This is like his fourth lawsuit. First one, very elaborate. We wanted a lot of relief. And I think we got engaged a little bit back and forth, and they dismissed the lawsuit. Motion to amend the lawsuit. Here's an amended lawsuit that asks for different relief, so there should be no objection to this lawsuit by the government. And the judge objected. The magistrate said, no, we aren't going to let you serve summons on this one. So he simplified it again, down to asking only this. And let me dig up the document. You're going to be shocked. They just dismissed this, saying you can't pursue. Hang on, it's a riot. Okay, it's a spectacle. And recall at this point what my disclaimer was. Nothing you're going to hear is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. You got to hear this one. This lawsuit was just rejected. I haven't even read the reason why yet, because you can't dismiss this thing. You got to spare me. When you hear the relief requested, here's what he can't sue for. Let's see here. We know the Taxpayers' Bill of Rights says you have a right to clear explanation of the laws in all IRS proceedings and controversies. The right to be informed. This is the first thing the Taxpayers' Bill of Rights says. Taxpayers have the right to know what they need to do to comply with the tax laws. They are entitled to clear explanation of the laws and IRS procedures and all tax forms, instructions, publications, notices, and correspondence. Okay. Then it comes to, and I'm gonna read from you, because it's a hammer. It's so simple. I could quote it verbatim, but man, you just don't get a sentiment like this wrong. You got to get it right, because it's a gift from the Supreme Court. Here is Helvering versus Texpen Oil Company, 1937. Quote, the taxpayers were entitled to know the basis of law and fact on which the commissioner sought to sustain the deficiencies. End quote. That's before somebody figured out the tax code. Now that somebody knows exactly which arguments to make, we can't talk about the law, and you aren't entitled to that anymore, because this lawsuit was just dismissed. This is all he's asking for. Cause of action, number 1, 2, and 3. Under the Administrative Procedures Act, asking the court, this is 5 U.S.C. 706, the reviewing court shall, what's this first, this 5 U.S.C. 706, Administrative Procedures Act, to the extent necessary to decision and when presented, the reviewing court shall decide all relevant questions at law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. The reviewing court shall compel agency action unlawfully withheld or unreasonably delayed, and a bunch of other stuff, but that's the one we're suing under. And he goes on to ask the court merely for this: please compel the IRS, because it's long overdue, to establish a database with the clear explanations of the laws that they promised in the Taxpayers' Bill of Rights. for all statutes and regulations. That was cause number one. Cause number two is let's see here. Well, you son of a gun. He's asking the court to compel the IRS to establish a database for all regulations and statutes. That's his first cause of action. His second cause of action is this. Plaintiff has a right to know that the subject provisions, those are the provisions that make up his arguments, the ones I just outlined to you, he has a right to know that the subject provisions have operated as written and intended before suffering any loss of property or other right. Defendant has had the statutory arguments plaintiff seeks to make for no fewer than 20 years and still clings to decisions which do not concern in any way the plaintiff's subject provisions. Not any and all statutes like the first cause of action, just his subject provisions. So if you won't compel them to give one about every provision, just narrow it down to my list of favorite provisions. And here's his relief requested. As an agency action that is unlawfully withheld or unreasonably delayed, plaintiff requests that this court compel agency action to establish and disclose clear explanation of the laws, the subject provisions, in a manner and form compliant with the requirements of the Freedom of Information Act and to the extent contemplated by the Taxpayers' Bill of Rights and the Fifth Amendment of the Constitution. There. No, you can't have it. And so we narrowed it down after they beat up lawsuit after lawsuit saying, oh, you can't sue for that, can't sue for this, can't sue for that. Finally, it gets down to where, fine, we aren't suing them for anything. Please keep stealing from us. Don't stop collecting or assessing anything. We just want the court to compel them to say what the law is. If the court won't say it, which is the court's duty, Marbury versus Madison, quoted in U.S. versus Lopez, 1995, and since. It's the judiciary's duty to say what the law is. We have to sue the United States government to get the court to order somebody else to say what the law is. That's how potent this argument is and how pathetic a thief is willing to appear to keep from having to admit, all right, all property is a cost. I'm sorry. Okay, it's the Fed's money now, pal. They need cruise missiles and aircraft carriers to shove up everybody's oil-rich country and light camels on fire in countries whose names we can't even pronounce. And that's why they need this money. But somewhere way back when, a bunch of bankers got together, creature from Jekyll Island, and said, why don't we steal from a nation of 310 million gun owners? And they did it, and they've been doing it. And my materials are available through Mark. If you want a consultation about more than just the materials he'll tell you about, please set up a conference call with Mark, and we'll get it on. And when people subscribe to these findings, what you're doing is you're fitting so like a glove into the Supreme Court's description of criminal intent in a reminder case from 2015. They said, in 1952, you screwed this guy named Morissette, and he took your case all the way to the Supreme Court, and we had to reverse his conviction because you didn't consider criminal intent. Oh, I'm sorry. And then they set it aside. And again, for all these years, I just had my 29-year anniversary since the IRS made me angry, like April 15th. And all this time, I've been wondering, these people don't intend to break the law. They're filing Pete Hendrickson tax returns. They might do things that the government thinks is moronic, but they have to consider whether or not the person thought they were within the law when they did it. If somebody files an OID and they get indicted for it, that's one thing. They probably didn't intend to break the law. They took a seminar and got in a bunch of trouble, or filed liens against public servants. But if somebody filed a claim for refund in several different IRS offices, looks like an effort to get several refunds, and that's fraud. So I'm not talking about that. I'm talking about most of the movement's efforts to find remedies, methods that might keep you out from underneath the wheels. And we find over and over again there really aren't any because it's theft. The government knows it. We know it. Now you know it. And the criminal proceedings always begin without an inquiry. Hey, did you know you're breaking the law there, Citizen Breath? We could arrest you for that. What were you thinking? The government never starts with that. Never. First things first, they got to get you in boxer shorts that are 4 sizes too big and an orange jumpsuit that's made for Wilt Chamberlain and lock you up with a bunch of poverty retardates. That's the first thing they do. And from there, man, that's an incentive to plead guilty. Just anything to shorten this punishment because it's already begun. And that's how they win. 95% plea agreement rate in the federal government, federal court system. So you have to be careful and know when you've relied strictly on the law. I've watched it work where people get on board with statutory arguments, code pleading like this, without waiving any rights, without conceding any status of any nature, just to tell the government, I think you're stealing every penny you're getting from me. What were you thinking? I can arrest you, right? In the back of the Section 83 manual, you'll find the paragraph out of each one of those cases I told you I found on citizens arrest, all in one place. You find all the case law in Section 83, the briefing of it, a manual that explains all the basic principles of law, maxims of law you need to understand to know when the government says the value of something. How do you determine the value of it? Well, it's determined through the terms of an arm's length transaction, set of a transaction negotiated between 2 unrelated parties acting in their own best interest under no compulsion to buy or sell, all relevant facts disclosed. U.S. versus Cartwright, 1973, Black's Law Dictionary, 6th edition, page 109, arm's length transaction. These are things I did in 1992. And I've been watching them ever since. I know my work inside and out. I have a 58-page memorandum that went in January 1st of 06 to those 80 members of Congress. I used to be able to go through that table of authorities that lists all the provisions and case law cited in the memorandum and tell you the text of all the statutes and regulations and tell you the reason I cited each one of the cases that was listed in that table of authorities. So I'm heavy into this, and I'm in it for the justice. If I was in it for the money, I'd have straight teeth by now. So this has been about the justice, and when you see the price of my materials, very reasonable, and understand I'm the only one code pleading against the IRS on the biggest of issues. So with that all having been said, Mark, let's save a little bit for next time, maybe answer a couple questions.
Okay, yeah, I've got one on that lawsuit where you've narrowed it down, just asking to explain certain aspects of the law. Obviously, they can't do that because if they did, they would expose the fraud. So what do you expect out of that?
Oh, I expect absolutely nothing. I restrict my work to criminal. And what these people wanted to do, these Americans, and only because they had the money to afford the filing fee and some incentive pay to keep me involved. There are other people that could not afford it, of course, that very much would like to have done this. So I'm not at all detracting from anybody else I'm not singling out these plaintiffs as good Americans as opposed to bad ones. I'm just saying I came across some people that really wanted to put some teeth in their statement to the government that I don't owe you a dime under the tax code. I know it. Here's proof of it. You run from it. I know this. I've seen all the briefs. I've seen all the exhibits going back to 1994. And so I know all about it, but I'm here to make my own statement that you can't prove to me on my own docket number that I owe a tax for these 2 reasons. And then we set about hitting them with the arguments to see, number one, are we going to be allowed to issue summons? And if not, well, I tried. Now leave me alone over all this money. I don't owe any of it. Don't push me. I can arrest you. Well, and I don't use the word default. I just say I don't have criminal intent, and so I'm not criminally intentional. Leave me alone, with the hopes that they won't take my money, but with the knowledge that every judge is as corrupt as the day is long, they'll get my money. And so I just don't do civil. It's so fruitless and monotonous and depressing that I take every case personal. I really want the best for whoever needs help. Again, that's why I'm in this. And it's the justice I want, whether it's for me or somebody else. And so their headache becomes my headache. So I just don't do civil, and I try to get people to do things preemptively so that criminal charges really can't reasonably be expected in their future. They've done so much to go so far to say, not only do I not have a duty, I can arrest you, servant breath. That's somebody they don't want on the witness stand in a criminal case. That's what I try to create.
I was just going to say that there is a 100% guaranteed way to win the civil cases, and that's to, as you said, act preemptively and don't ever let it happen, which is what I was saying at the beginning of the presentation. Just get that out of the way.
Which is what we were trying to do at that summons hearing, is to make it such a sour experience they didn't sue him for the records, because he's in their face with it, and now he's got it transcribed. He served it on them, notarized, saying, you can't even explain the law to me. Don't talk to me. Do they want to face that transcript in court? I was brought on to make his summons hearing as bad an experience for those people as possible, so that if they do recommend a civil suit to get his records, the DOJ will look at that and say, well, we don't want to face this exhibit in court. That's the only reason I spoke to him. I don't do civil.
Yep. And that's a good example of setting the record with your documentation for just that purpose, because it may be needed in court at some time. And whatever you're doing, whatever processes that you have out there, set the record with good documentation. Not that the documents are going to perform any magic for you, but if push comes to shove at some point in time, they could take a look at that and say, no, we don't want to bring that onto the public record.
Well, also it makes the controversy, if I'm saying, hey, you're a bunch of racketeers, it makes my trial their trial. Also, if I'm calling them a bunch of racketeers and they don't back off, I've got a bunch of ammunition now. I could tell the judge, you've got a criminal complaint served on you, Your Honor. They're asking you to become complicit. Put the law on the record that proves you're not, because they're asking you to act right now in a manner that will subject you to citizen's arrest by 310 million Americans.
Are you ready for that?
I didn't want to be a judge. You did. Okay. But we all have rights here. And you can't deny the right of citizen's arrest of a felon, and the government can't deny they're asking you to be a felon. You're the one that wanted to be a judge. You're the one with a question in front of you. But, just seems to me it's a pretty important one you ought to ask before you could bang that gavel on me.
Yeah. Let me ask you, we're talking all about the IRS and the mens rea. In your training course, you get into other applications of that. Seems to me that would apply across the board.
Well, I start with the beginning. The beginning, for the purposes of the course, is 1952. Because in 2015, the Supreme Court got a case under 18 U.S.C. 875, interstate communication of a threat to kidnap or injure. Alonis, Anthony Alonis, a burgeoning rapper. 40 years old, and you can already hump, spit, and swear at the children. I'm impressed. I digress. He posted, Did you hear about the rapper that won the spelling bee? Don't be naive. Anyway, he posted a bunch of ballistically overtly violent rhetoric on his Facebook page about his ex-wife. Hey, the best place to go to launch a murder at her house is the cornfield beside her house, because there's an access road that you can get away on. hey, I'm not worried about the state and federal police because I got enough explosives to take care of them. Then he says, hey, hell hath no fury like an angry man with a shotgun in a middle school. And so he was charged with communication of an interstate threat because the internet is interstate commerce, and to kidnap or injure. And he took it all the way to the Supreme Court because at trial, at trial, the district court said, no, we won't let you give that jury instruction to the jury. If a reasonable person looks at what he posted and thinks it's a threat, he's guilty. What was that jury instruction? We want the court to instruct the jury that if he didn't have criminal intent in what he wrote, then he's not guilty because mens rea is lacking. It's an essential element. And the court said no. And he took it all the way to the Supreme Court because the appellate court agreed with the district court. And if he hadn't gone all the way to the Supreme Court, the appellate court ruling would stand. And the Supreme Court said, excuse me, but in 1952, you tried the same thing. Morissette versus U.S. Here's a guy out on a government practice bombing range in 1948, something like that. And everybody goes deer hunting there in the wintertime, and the government just lets these long dummy canisters that have gunpowder in them with a bunch of sand that they drop from the planes, and the gunpowder leaves a puff of smoke so the pilot could track their accuracy. And they'd let all these canisters stack up, these shells, and they'd scrape them to the side once in a while with bulldozers, and they'd rot away in the weather. And Morissette goes out deer hunting. He gets skunked, and to recoup some of his costs of the deer hunting trip, he says, why don't I scoop up a bunch of these shells, these dummy shells, and sell them as scrap metal? And so he scraped up about 2 or 3 tons of them. He was a scrap metal dealer. And in the summertime, he operated a vegetable stand. And the government came after him, said, we suspect you took some stuff off of that property. He goes, yeah, look, I got all these, I crushed them on the property and I sold them as scrap metal, and told them everything as soon as they found him. Obviously, he didn't think he did anything wrong. Full disclosure upon first discovery by the government. Yeah. You're going to jail. No, they told him $200 or a month in prison, something like that. It was very inconsequential. Took it all the way to the Supreme Court. And the Supreme Court said, this is really an insignificant case, except for the fact about the way the jury was instructed could have wide-ranging effects and ramifications on federal criminal jurisprudence. And they said, you have to instruct the jury on criminal intent. And in 2015, they overturned that conviction for transmission of an interstate threat with the option. Well, actually, it was passed. I think it was passed 5 years later, so they couldn't retry the guy. Statute of limitations was up. So anyway, overturned the conviction. And then Alyssa, I think was her name, Alyssa Martinez, was coming up through the Supreme Court at the same time. She had sent an email to a radio station saying, hey, it's about time we went to the school board meeting and taught them all about the Second Amendment. You bet. I'll see you there. I'll have mine, whatever. And pounding her chest. And later called up or emailed saying, that was my husband. He's on Prozac. Ignore it. And she got indicted and convicted for transmission of a communication to interstate communication, the same statute. And the argument was there's no criminal intent alleged in the indictment. And the Supreme Court said, based on aloneness, her conviction's vacated. In one sentence, they didn't even write an opinion. I've never seen that. A summary dismissal based on another decision. They said, based on aloneness, no problem, and overturned a conviction. And so now you have this standard that the government in 1952 became fully aware of, and they set it aside because they'll just get the indictment first and then beat you up until you plead guilty. They never have to consider criminal intent. And the Supreme Court spanked them in 2015, and then in the Alyssa Martinez case. And then 6 months later, a district court, like, I don't know, First Circuit, I can't remember, says, well, that doesn't apply in anything other than that statute. The Supreme Court said that was a decision about that statute's construction.
Oh,
And so it doesn't apply. And so it doesn't apply, Gesundheit. It doesn't apply to the extortion schemes in this case. And 6 months later, the Supreme Court comes out with another decision saying this is a blanket rule in the background of every criminal statute. So, checkmate. So anyway, the topic is hot. I did segment number 1 about the Supreme Court decisions. And then a couple months later, I did segment number 2 about the lower court decisions that were overturned and why. And segment number 3 is about the anti-tax movement or patriot movement. If you think you're right, and I'm talking right to travel, state income tax, the rest of them. If you think you're right on these fronts and you want to confront the government in these ways, I don't help guilty people, okay? I'll help you when the government comes calling. They should really keep it in their pants. In such an instance, you really want to go on record with the law so you know at least criminal charges will be much easier to prevent, even much less abate once they're brought. Okay, it's hard to beat a case that's been commenced because prosecutors hate to lose, and so do judges. They're not on your side. So you really want to preempt them in advance. You tell them everything you know about what you're going to do and why they should leave you alone about it. And if they don't counter you, that you'll proceed without the intent to break the law, doing what you told them you'd do. And if it's a real tough one, like, excuse me, but open as a matter of right to public vehicular travel. I said, tell them everything you're going to do. And if they don't counter you, then it'll be a lot easier to counter. If anything comes down, it might even prevent something from happening. Oh, motor vehicle code. This hurts. Google. Open as a matter of right to public vehicular travel. 774,000 hits. I got on that same link to Google search, open as a matter of right to public vehicular travel, just the other day on the same website with the same link. I got 37 million hits. It's in the law from coast to coast everywhere that the highways are open as a matter of right to public vehicular travel. It's in the law. I'm a code pleader. I don't plead I have the right to travel. I plead the motor vehicle code has a limited scope. And so don't apply it to people that aren't in the definition of motor vehicle. As you see, it was originally codified in 1909, 1915, whatever it was in your state. In Washington, it was 1915. Through 1921, there's a very particular set of definitions that obviously only direct the motor vehicle code at people engaged in commerce on the streets. So I don't say I have a right to travel. I say you have a limited authority. You're committing extortion and racketeering, misapplying a statutory scheme to steal my money. It's over. Motor vehicle fuel excise tax, motor vehicle tire excise tax, motor vehicle emissions, motor vehicle traffic infraction, motor vehicle insurance. What about automobiles? The motor vehicle code didn't say anything about automobiles. And here in Washington state, in the second degree motor vehicle theft statute that was rewritten in 2003 to make it more stiff because there was a wave of car theft here in the Seattle area, they revisited it, and even in 2003, they kept this language and even added it in another paragraph. If anybody takes without permission this, that, and the other thing, an automobile, comma, or motor vehicle, in 3 places. And so even to the state legislature, the automobile and the motor vehicle are 2 different things, and the motor vehicle code doesn't mention automobiles. Well, I think automobile is what I'm driving. It's what I paid for when I, handed over my money at the dealer. When did it become a motor vehicle? And you're just dying at that point for the judge to say, well, you got license plates on it. Thanks, Your Honor. Go ahead. My mistake, find against me. I'm going to take those plates off right now. My mistake. Okay. It'll never happen. They'll never say that, but that's exactly where you've pushed them to. That's funny.
That's good. That's good.
Oh yeah.
Oh.
From fourth grade through high school, I eat, slept, and breathed chess. And I'm a super competitor. And my dad had red hair. That's 0 for 3. Officer.
Irish, huh?
Norwegian.
Oh, okay.
Berserks.
Yeah. Okay, so
No, hold it. The case from the Supreme Court. Just a second. And that's the second Supreme Court case, criminal intent. Let my external hard drive catch up to me here. And I know just where to find it. It's it's funny to see that 2015 case, and then 6 months later, a district court goes, "Oh, no, well, that only applies in that case." And then 6 months later, the Supreme Court goes, "This is apply." It just threw a blanket over it. It's really comical. You don't see that very often at that high of a level. That's amazing.
One of the things I learned in going through my court processes was that every criminal charge, the prosecutor must prove certain specific elements to get the conviction. And those elements must be proven beyond a reasonable doubt. So in the event you ever have a criminal charge filed against you, the first thing I would do is to look up what are those criminal elements that must be proven. What do they have to do in their case to get the conviction? Okay. And this is one of the things that David's talking about is mens rea, is willful intent. Just to repeat again what I said earlier, which I learned from David, in fact, listening to him in other presentations, is that to have for them to prove willful intent to violate the law, first of all, you must have a lawful duty. A lawful duty must exist. Okay? So they have to be able to show in the law what that duty is. Number two is you have to know about that lawful duty. All right? So that has to be shown. And then number three, that they have to show that you willfully violated that duty which exists lawfully. Okay? So that's kind of what it breaks down to willful intent. And I was going to ask you, David, if criminal charges are filed, what can a person do to try and nip this in the bud? It's my understanding that from listening to some of your comments in other venues that a lot of the prosecutors these days don't pay any attention to this issue. They don't try to prove willful intent that you knowingly violated the law. So my question is, a criminal prosecution is in process or even just filed at the very beginning. What can a person do using this knowledge of mens rea? And for example, your seminar, do you address that issue in the seminar at all, the training?
So much of it is reliant on preemption. You have to get in front of what they want to do. You know, there's plenty of people that, and this simply, it's a failure to reason. They study and study why people go to prison. And personally, early on, I said, I'm going to study why the government loses. And that's really when an epiphany occurred.
Yeah.
I only studied why the government loses a case. Who wants to study how the government kicks your butt? I want to study when the government fails and why, so that when I see, and this is how I started using this knowledge, was when I see a case go in a certain direction that means dismissal, I push it there. You bet. I have a case in Washington State here that says mere mismanagement of discovery is grounds for dismissal. Well, I want to read the briefs in that case, and then I want to make sure the prosecutor in my case, or the case of the person I'm helping, is overworked. And I will beat them like a rented mule over discovery. I want everything they ever heard of, and I want it now. And so hopefully they'll violate rules about disclosure, which leads to a decision in my favor saying you've mismanaged discovery, grounds for dismissal.
There you go.
So when I'd see a case go in a certain direction where the government's lost before, I'd go, well, I recognize that right there. For instance, when I see the healthcare bill, and you can thank me later for not uttering the name of the president after whom it's named. The healthcare bill says, hey, you have to buy health insurance. Excuse me, right there. Put the brakes on. 3 arguments. I have the right against compulsory exercise of my rights. Did you know that right comes along with each one of your rights? You have the right to privacy, and you have the right to not be forced to keep your affairs private. You have the right to speak, and you have the right to not be forced to speak. You have the right to contract and to not be forced to contract. You have the right to associate and to not be forced to associate. You have the right to enjoy your property and to not be forced to enjoy your property. They can't force you to contract, associate, and spend your property in the realm of private commerce. They have to require you give the money to the government or shut up. And so right there, just because I know my rights, they trigger my knowledge with this action of theirs saying, excuse me, you have to associate with a private insurance company. No, I don't. And I would make that argument. But you don't know that argument until you study what your rights are. You don't know what your rights are until you study why the government loses. Don't study why the government wins. That's when you study the government's authority. Study your rights. And wow. I'm going to read both of these. Here's Alonis, 2015, Supreme Court. The fact that the statute does not specify any required mental state, however, does not mean that none exists. We have repeatedly held that mere omission from a criminal enactment of any mention of a criminal intent should not be read as having dispensed with it. See Morissette versus United States, 1952. This rule of construction reflects the basic principle that wrongdoing must be conscious to be criminal. As Justice Jackson explained, this principle is as universal and persistent in mature systems of law as belief in freedom of the human will and a consequent ability and duty of the normal individual to choose between good and evil. Supreme Court, Elonis, E-L-O-N-I-S, Elonis versus United States. 135 Supreme Court, 2001. 135 Supreme Court 2001, June 5th of 2015. Now I'm going to read a quick paragraph from that district court case that said, it's just that case. Doesn't apply here. First, and this is the U.S. versus Kirsch, Western District of New York, District Court. First, Alonis is a case of statutory construction and as such is limited just to Section 875C of Title 18. No case reported thus far extends Alonis's holding beyond that statute. Well, it's only been 6 months. Wow. Did you hear that? No case so far has extended Alonis beyond that one, so I'm going to limit it to Alonis. He says, second, the Alonis court, as a matter of statutory interpretation, read a mens rea requirement into 875 only to separate wrongful conduct from otherwise innocent conduct. It applied that rule of construction to uphold the principle that wrongdoing must be conscious to be criminal and a defendant must be blameworthy in mind before he can be found guilty. In the absence of mens rea requirement, 875 is what drives Alonis. Oh, okay. So it doesn't apply to the extortion schemes in this case, is what he was telling you. However,
How arrogant.
6 months later, the Supreme Court, we just heard that, oh, well, no case since Alonis has applied it beyond that statute. Well, okay, the Supreme Court must have become aware of this because they say in Torres versus Lynch, Torres, Torres versus Lynch, 136, Supreme Court, 1619. That's 136, Supreme Court, 1619, May 19th of 2016, 2 weeks less than 1 year after Alonis. Consider the law respecting mens rea. In general, courts interpret criminal statutes to require that a defendant possess mens rea or a guilty mind as to every element of the offense. See Alonis versus U.S. Well, that pretty much just stabbed that other judge, didn't it?
Yeah.
Because he's saying, oh, it only applies to 875C. In general, courts interpret criminal statutes, not just 875C. Courts interpret criminal statutes to require that a defendant possess mens rea or a guilty mind as to every element of the offense. You transmitted a threat in interstate commerce. Well, excuse me, but my name is Joe. I live at 1285 Maple Street, and I sent an email to 1281 Maple Street saying, keep your dog off my lawn because I have to clean up the crap every morning. How was I to know that my message traveled interstate? 4 doors down. Your dog is on my lawn. Interstate. How is Joe Lunchbucket supposed to know that? And where is he going to pick up that tidbit of information between shifts on his drill press? 1994, Ninth Circuit, Gasho versus United States. It is fundamental that a person is not criminally responsible unless criminal intent accompanies the wrongful act. Consequently, to have probable cause to believe that a crime has been committed, an arresting officer would have to reasonably believe that Sharon Gasho intended to defy and frustrate the seizure at the time that she removed the logbooks. End quote. This was a case, I read it a couple times. I can't remember if it was a boat or an airplane. She removed the logbooks from a decommissioned vessel or plane. And the allegation against her was that she did it to defy and frustrate the seizure of that vessel or plane. Now let's take away the particulars of her case and apply the general nature that we just heard in the Supreme Court to this sentence. And I'm going to broaden it out from the Ninth Circuit quote here about Sharon Gasho, and let's incorporate what we just learned from the Supreme Court. Consequently, to have probable cause to believe that a crime has been committed, an arresting officer would have to reasonably believe that the suspect intended to violate each essential element of the statute the officer thinks may have been violated. Can you hear the burden that places on every arresting officer? Every officer out there that thinks they might have to make an arrest. What are the elements of the crime? Well, we know one of them. It's not in the statute, probably, but criminal intent is part of every one of them. Shouldn't the officer turn around in their patrol car to the back seat with you in cuffs back there, sitting sideways because you're in a shoebox, right? Hey, did you know what you're doing was illegal? Did you know? What were you thinking? if you say something like, screw that bitch, whatever, well, then the officer knows pretty much it wasn't because you thought you were innocent, it's because you had something out for somebody. But if you say back saying, what the hell kind of law would prohibit what I was doing? It's my damn flag. I set fire to it. Well, right there, the officer just received proof of innocence. And so the arrest was illegal because I got case law that says I can burn my flag if I want. Suddenly, the officer is in violation of clearly established law, meaning they can't claim qualified immunity. And if the municipality knew, of course they knew. It's a Supreme Court case that says you can burn the flag. You know that If you were arrested for it, the municipality is therefore also liable for tort damages. Things you got to know. Couple questions, Mark, and we're out of here.
Okay.
My pleasure.
Yeah. Gerald Del Verde is asking, will that also apply to securities issues where they're saying that they didn't say that he knew he was violating a security or he knew what he was doing was a security?
Okay. Securities laws are broadly enforced for public protection. SCOGMO, SKOGMO. I'm going to scholar.google right now. Scholar.google.com, case law federal, and I type in SCOGMO. And again, this is work I did in 1999. And it comes right up with a case of Gersel versus Gamble SCOGMO. That's the one. And it's about securities. And it says broadly enforced for public protection. And a whole bunch of cases cite SCOGMO. So I have this photographic memory problem. I can't forget stuff, but I'm running out of places to put it. And, you know, it's like, you won't meet a lot of people with that particular problem, but there's one on the line tonight. And securities laws are broadly enforced. I have to go find that link again on Skype. Hang on just a second, Mark. I'm multitasking. Here we go. SCOGMO, generally enforced securities laws, and it sweeps up a lot of people that are barely guilty, if guilty at all. I had a series of courses I used to offer. The first one was how to tell whether or not you're guilty. Gifting clubs across the United States were prosecuted 1999, 2000, 2001, 2002 as pyramid schemes, pyramid promotional schemes, chain distributor schemes. And I did an analysis of 33 states' pyramid scheme statutes, and I had a professional opinion letter for each of those 33 states. So when I'd encounter a gifting club member from a certain state that said, I'd like your sworn affidavit opinion letter about whether or not in this state my gifting club typical operating procedures violate the standard, the definition of pyramid scheme. And across the 30 states, none of them were guilty. And the government was so hard pressed because of the analysis of statute I did compared to the gifting club policies that they went out and used securities fraud statutes to punish these people instead of pyramid scheme statutes, because security statutes were much more broadly enforced and much more broadly worded. So you need to be careful about securities. If you want my annotation on securities, get a hold of Mark. I'll be glad to give that to you. That'll be tonight's freebies, Mark. Why don't you, in fact, I'm going to give you 2 freebies on this call. Okay. The annotation on securities. Just get a hold of Mark. He'll forward it to you, okay? So email Mark at the address he chooses, and he'll email you 2 freebies. My annotation in Microsoft Word on securities enforcement. And make a note of this, Mark. The second freebie is tattoo.zip. All lowercase, no spaces. TATTOO.zip. You're going to have a hernia when you take the tutorial on tattoo.zip. I'm serious. It's one of the funniest damn things I've ever done to the government. There was and this tutorial is great. Okay, you unzip it, you open it up. There's going to be a folder that says "Don't open this." You know what that means? It means don't open it. There's going to be a file that says "Open this first." It's a web file. Open it up like a website on your computer. It has an audio control. You just click on play, and I'll talk to you and tell you about the documents you just got in Microsoft Word and how we sprung this trap on this judge. My job was to only get the judge off of the case. How are you going to do that, Dave? Oh, I know exactly how to do it. You just get me a tape recording of that hearing, and you'll hear the hearing in the recording in the tutorial. It's a 2-minute hearing where the guy shows up to court, and 2 minutes later he's arrested for contempt of court, but the judge didn't allow him to allocute. Before you arrest somebody for contempt and before you sentence them for anything, you have to allow them a chance to tell the court, sorry, or I'm not as guilty as you think I was, or go easy on me, or whatever. And in contempt, it's especially important because for summary contempt, bingo, you're in jail. There's no hearing or anything. Oh, excuse me, but you're wrong. You at least get the opportunity to tell the court that you're either not in contempt or didn't mean to be in contempt or something else to mitigate how much the judge wants to do to you. It's a Fifth Amendment right. And so they deprived him of his rights. The judge and 2 bailiffs. That's a conspiracy against rights. That's a federal felony. 10 years in prison. Title 18, Section 4 requires you to report felonies to the government.
Whoa.
So I get this phone call Tuesday morning, and from a promoter I had in California. You'll hear him on the recorder, and he'll tell you, I tuned into Dave's calls first off, I said, and he knows everybody in the movement. He's on a first name basis with everybody that has an organization. Everybody, Free Enterprise Society, everybody out there, he knows them by first name. And on this call, you'll hear him say that when he first heard me, his first impression was, what a windbag. Nobody can do any of this. The system does not work like this. No way, no how, no chance. Because he'd gone to court and gone to court and gone to court and watched everybody go down in flames with all these other philosophies, myths. And nobody can do this. And so he started listening and looking up everything I said. And 3 or 4 months later said, can I be your promoter? Because I'm the only one on offense. And on this tape, he called me up on a Tuesday morning and said, I went to court here with Al. Last week, the judge says, threw him out of court, had him thrown out of court and said, I find you incompetent. You have to go see these 2 psychiatrists, Smith and Stevens. And so instead he went to his own psychiatrist and said, give me a letter that says my poop is in a group. And so he goes to court the next week, and the judge says, I got a letter here. This is Judge Lisa Novak, a 2005 Arnold Schwarzenegger appointee. I got a note here from Dr. Joshua and Dr. Jones that says you didn't go to see them as I ordered. Do you have an excuse for that? Or a reason for that? He goes, yeah. Do you have a reason for not recusing yourself? She goes, remand him into custody, contempt. Well, he wasn't ordered to go see Jones and Joshua. He was ordered to go see Stevens and Smith. And so he was not in contempt the way she accused him. Do you have an excuse for not going to see these guys? Yeah, best one in the world. You didn't tell me to go see those guys. But he says, yeah. Do you have a reason for not recusing yourself? And she goes, remand him into custody. Because he'd been telling her under arraignment rules, I still haven't even been properly arraigned. And you ignored court rules. I want you off the case. Recuse yourself at previous hearings. And she wouldn't. And so when she said, do you have a reason for not going to see these doctors? He goes, yeah. Do you have a reason for not recusing yourself? She goes, remand him into custody. It's right there. You can hear the hearing. And you hear the cuffs going on him and everything. It's a 2-minute hearing. And you'll hear Craig describe how I've been to court and seen all these people go down in flames, and I'm going to court with Al and I'm trying to coach him. And I heard the power of what Dave had to say, but I hadn't seen it in action. And that day she forced him out of the courtroom, said, come back here. And when he wasn't in contempt and didn't get to allocute, she arrested him, man. And I had to pay $800 to get him out of jail this morning. And here he is on the phone with us. Dave, any ideas? I said, yeah, tell me about it. Tell me these things. Did you tape record it? He goes, oh, yeah. I said, okay, send me the tape recorder overnight. I want it tomorrow. And by Friday, be ready to file paperwork. And so by Friday, they're filing the paperwork. You'll see it's included in the tutorial in Microsoft Word. First things first, an affidavit about what went on in the case. And so I wrote a quick affidavit for him to notarize, I think, and attached a cassette copy in a baggie to each one of these criminal complaints. So the criminal complaint affidavit was him saying, under state law, since I have a right to allocute, and since I was not in contempt, and she would have known that if she'd have given me a chance at allocution, then she and the deputies are guilty under state law of kidnapping, life in prison with the possibility of parole because I didn't get hurt. And the deputies are guilty of battery. And the deputies are guilty of second-degree assault. And the three of them are guilty of extortion under state statutes, a criminal complaint under state law affidavit that has an exhibit attached, which is the hearing on cassette, Stone Age. And and these are documents I emailed to them on Friday. So I had 24 hours on the job, 3 8-hour shifts, and I was done with this approach. Bingo. State criminal complaint with exhibit cassette tape filed across town in another state court against the judge and 2 deputies, 2 bailiffs. And then his remaining 6 or 7 copies, date stamp received by that court. And then they go to the FBI and put the federal criminal complaint affidavit on top of the state complaint affidavit and serve the FBI and get all their remaining copies, date stamp received. So the stack is growing. Then they go to the bean counters with the county and say, I'm suing the county for false arrest, and put that claim for damages affidavit on top of the 2 criminal complaints in the exhibit and serve that on the bean counters at the treasurer's office for the county. And then put an affidavit of prejudice on top of the criminal complaints and claim for damages and filed it back into his case saying, I want the judge to get off the case. The appearance of fairness is lost. I've complained to have her removed from her job and put in state and federal prisons with the possibility of parole. And on the tape or on the recording, Craig will describe he was in court and he saw, not as the defendant. The defendant is preoccupied and should be. But Craig was the spectator, and he had already been a court watcher. Listen to what he says about what that judge had to have taken a bit off a mouthful of before she came into court. He says she was a walking 2x4. It was like she was strapped to a plank. She sat down like a robot. Said one thing: your rights are very important to us. Welcome to court, Mr. Centraletti. The court will always look out for your rights. I'm stepping away from this case. Your new judge is Judge Johnson. Your next hearing is Tuesday at 9:00. And got up stiff as a board and walked out. And Craig said the 2 of them got to the steps of the courthouse on their way out and just died laughing. They collapsed. They were laughing so damn hard. And finally got embarrassed because they were in front of everybody laughing on courthouse steps. They said they made it to the car. And as he pulled away from the curb, he was still dangerous behind the wheel. They were laughing so hard at what those criminal complaints did to that judge because they're written better than everything they see from the prosecutors. The law had not been in that courthouse in years. And the complaint went from a tattoo quote unquote artist that has tattoos in places you can't see in the shower, head to toe, and piercings. The pleadings came out, and it went right to the top of the court to the judge, a superior court judge, and knocked her right off the bench into submission with criminal complaints that stacked up on her that probably got phone calls from the county going, did you really do this to the guy? We have the cassette tape, you know. Okay. And she couldn't get away from the case fast enough. All I was trying to do was get her off the case. That's all I was trying to do. But I told these guys what's going to happen is the second judge is going to come in and look at her and go, I don't want to feel like she does. I don't need some document like that filed against me heating my courthouse. And he's going to come in and he's going to calm everybody down.
Watch his piece.
Yeah, that's right. Well, he's just gonna be your father. He's gonna come in there, settle down, everybody. What do we have here? And that's exactly what he did. This guy didn't even ask for a public defender. But there was one there to make sure the word criminal complaint was not uttered on the record. And the judge says, "How is everybody this morning?" The public defender stands up and just takes the floor saying, "I'm here to represent Mr. Centraletti. My name is so-and-so from such and such a firm. It's come to our attention that speedy trial rights have been violated in all this on this date and this date and this date." And the judge looks to the prosecutor and says, "Is this true?" Because the judge wants to get rid of it too. It's a pitsy little misdemeanor charge trumped up against somebody they wanted to run out of the city. Okay. And the prosecutor goes, "I'll get back to you this afternoon." The judge goes, "Good, do that." Next case. And that afternoon, the prosecutor calls the public defender and says, "Yeah, speedy trial rights are violated. We're dropping the case." So anyway, listen to somebody else's description who, when he first encountered me, thought I was a real windbag, a real ass. The most arrogant guy that ever picked up a law dictionary and became my promoter, and then didn't really feel the power. And he said, "After this day, I could see that you didn't just shock the court, you shocked the system, because it hadn't been in there in years." And enjoy the tutorial. I'm glad to give that to you as a freebie. And remember, as you look at those documents, you aren't going to find prosecutors that write that well. And in my courses, I'll teach you my formatting settings and how to adapt my criminal complaints to your own case. I got a course on how to write and file citizens' criminal complaints. And you get a bunch of examples in Microsoft Word that I wrote for other people around the country. And I took their name out and I put Joe Lunchbucket in there, but they're actual examples of federal and state criminal complaints I've written across the United States since 2001, when I first got the idea that I should do that. I didn't get any respect until I did. But once I started filing those, man, I could tell the judge told somebody, "I don't want him in my courtroom unless he's breaking arms and burglarizing homes." Because every time he comes in here, he pushes us into court rule violations, and that's a criminal complaint against the judge. So leave him alone. And I drove for years without license, plates, insurance, an expired trip permit in the window. Nobody wanted to talk to me. So I didn't get respect until I started wielding the criminal code against public servants and add the cream, add the icing to that. And that is, when you prove it's a felony they committed, you now have rights. Everyone in the United States now has rights. Everyone who comes here from Indonesia or Malaysia or Qatar or Pakistan has rights to arrest the felon.
Yeah, very true.
Get my courses. I'm on the offense. I'm the only one on the offense. Everybody else is playing defense.
Well, that's the only way to win. You can't win defending yourself. You know, they've got their ways. And here's one thing that I found is that the players in the courtroom are so used to doing what they do. One attorney greases the palm of the other attorney. They typically have things predetermined and how they're going to manage things and, manage the case. All right. So with that in mind, when someone comes into the courtroom who actually knows something, which is highly unusual, it throws them totally off their game. And when that happens, they tend to make mistakes. And you've got to recognize those mistakes. When they do, then you got to go on the offense, just like you're talking about, David. And that's the only way to win, is to go on the offense.
Well, listen to Craig in that recording, and he'll tell you that, before I went to court, and I couldn't really tell what they were doing. And after taking Dave's courses, I go to court and I see crimes all around me. It's everywhere. There is so much they get away with strictly by virtue of our ignorance.
Yep.
There's sometimes when they're screwing with you, that they're stealing, and there's nothing you can do about it. They arrested me, they took my cell phone, I'll never get that thing back. Then there's other things like, can they really do that? Can they cite me for public nuisance when I built my awning for my trailer out in the middle of my acreage? Is that really public? See, that's kind of where they get away strictly on our ignorance, but it's not overtly criminal like stealing your cell phone. And so you have to know more. But once you know more and you cure that level of ignorance, you recognize there's a whole category of enforcement where they're riding a crest of our ignorance. And the only thing standing between them and handcuffs is the corruption of the judge. And so you have to make your best case for getting the judge in trouble first. I'm not going to okay, you can't get a prosecutor in trouble until you know the cop's job. Can't get a judge in trouble until you know the prosecutor's job. Up the ladder. And once you know everybody's job, you can get the judge in trouble first. When I know how to get the judge in trouble, it's where I'm going to push every case first.
Yeah.
First things first. The judge is a criminal. Would you like to be arrested at home or when you get off work today? No one else talks like this. And I got all the case law in the world to back me up, statutory pleading, code pleading all the way. So even Lowell B. Craft can't debunk my analysis of the tax code and my conclusions about it. So, I don't want to stand here and call myself a genius and all this. I went at the tax code with more diligence, more responsibly, and more exhaustively than anybody else you'll see that says they have a curriculum. And if the first thing they have to admit to you is that they don't know anything about the statute that explains how to tax your paycheck, why would you do anything but turn from them and run? Really, you got a lot at stake. And there's a mention on Mark Stevens of a particular case that he's celebrating. Hey, 6 years of battle. I finally got these guys to back off on the lien and levy. Okay, back up from that just one step and look at that in adult terms. Do you really want a 6-year relationship with the IRS?
Yeah. What's involved in that?
You establish a home business. You gather all allowable deductions that H&R Block says the IRS will allow, and that's your best option. The only other way is to get involved with the IRS, and the law doesn't matter. Why would you wish that on yourself and your family? It'll change your body chemistry for the entire time you're engaged with them. Don't do that to yourselves. Get to where the dog won't even like you.
Probably
so really, you just pay a small price in the form of what they say are taxes, and you spend the rest of the time in a shouting match with your congressman. That's the best you can do. I want you to stay out of prison. I want you to stay out from under liens and levies, pay on a schedule that doesn't make you skip meals or better clothes for the children or gas for the car. Stay out of trouble, but at the same time, I'll teach you more about the law to acquaint you with the true fabric of your relationship with the federal government than anyone else can do. You have the same relationship with the federal government as you have with that person that'll come up to you at a red light and carjack your car with a crowbar. So,
yeah, good stuff, Dave. Good stuff. Well,
anytime.
I think the key lesson here is people need to be diligent and preemptive and not wait till problems occur. Position yourself properly, as we started talking this evening. Avoid issues, educate yourself, and maybe sitting like those toucans I showed you earlier, free as a bird. So,
and support Mark here at Lighthouse Law Club. So I'm out of here, men.
All right, David. Thanks. God bless you. Thank you very much for those freebies. And I think our guest here today made out pretty good between the free book I offered him and your 2 freebies. I think everyone here tonight is going to make out pretty well.
I hope you have a good night. And call me anytime, Mark. Take care, everybody.
Will do. Take care. Thank you.
Okay. Bye.
All right. Okay, folks, that'll do it for tonight. A lot of fun. It's great. It's great hanging around people that know what they're doing and can wield the power of truth and law to get justice. And that's really what it's all about. Just comes from knowledge. And you've got David and you've got the Lighthouse Law Club to steer you in that direction. So that's all for now. Come back next week. Bring a friend. And until then, have a great week. Take care and God bless everybody.